So I want you to picture a digital PDF just sitting on a standard creator storefront.
Okay.
And it has generated exactly 7 sales. Not, 7,000. Just 7.
Right. 7 total.
Exactly. Total revenue is $29. But today, that $29 digital file is the absolute center of a $100 million lawsuit.
It's wild.
It really is. Against Anthropic PBC, which is, one of the most powerful and well-funded artificial intelligence companies on the planet.
Yeah, it is the ultimate David versus Goliath scenario.
Yeah.
But is built entirely on this foundation of incredibly complex technical mechanics.
Right.
When you look at the stack of documents driving this conflict, you realize very quickly this isn't a standard copyright dispute.
No, not at all. And we have a massive stack of sources to unpack for you today to understand how we got here in this deep dive.
It's a lot of paper.
So much paper. We're pulling from formal legal summons, highly detailed tracking logs from process servers, United States copyright registration confirmations.
We even have those microscopic Gumroad storefront receipts. Yeah, the Gumroad receipts are fascinating. And a remarkably fiery pro se legal declaration filed by the independent researcher at the center of all this.
Seth Brunell.
Seth Brunell. And our mission today is to piece together this puzzle that involves, well, allegations of industrial espionage, the underlying math of AI hallucinations, and this fascinating legal chess move known as a strategic default.
Which is such a crazy concept because the cover sheet of the lawsuit just screams about this massive financial demand, right?
Yeah, that's $100 million.
Exactly. But reading through the actual filings reveals a completely different core narrative.
What do you mean?
Well, this is basically a battle over who fundamentally controls the stability, the persistence, and, ultimately the quote-unquote mind of an artificial intelligence.
Okay, so to understand how a $100 million lawsuit stems from a $29 PDF, I feel like we have to look at the proprietary framework that the PDF is actually based on.
Yeah, we have to start there. So in our sources, specifically Exhibit G and the U.S. Copyright Registration, this system is referred to as the third blueprint.
Right.
And the copyright was officially uploaded via the ecosystem on April 9th, 2026. Registration number 11513805529.
And what Seth Brunell claims here is that this third blueprint is a proprietary universal framework.
Okay.
And he says it solves literally the single biggest problem plaguing large language models today, which is foundational instability.
Right. Contextual drift. Which, if you use an AI for long enough, you've probably seen this. You watch it slowly lose its grip on the parameters of the conversation.
Oh, absolutely. Because at their mechanical core, these models are just incredibly sophisticated predictive text engines.
Just guessing the next word.
Exactly. They are calculating the mathematical probability of the next word based on their training data. So when a conversation gets too long, the context window gets bloated.
Right.
The mathematical weights start to degrade. The AI just loses the thread or it suffers a hallucination.
Confidently generating completely false information just because a random probabilistic weight skewed in the wrong direction?
Exactly.
Okay, let's unpack this. It's kind of like having a hyper-competent librarian in a massive library with, billions of books.
I like that analogy.
Right. And you ask them to find information on a very specific topic, and they start out strong, but after walking through 10 different aisles, the sheer volume of information just overwhelms their original directive.
Yeah, they get lost in the stacks.
Literally. And suddenly, they are handing you random pages from a 19th century cookbook because the word apple was mentioned one time in your original prompt.
That captures the operational degradation perfectly. The model gets distracted by its own vast ocean of parameters.
Right.
And Brunell's third blueprint claims to act as a deterministic constraint layer to stop that from happening.
Okay, deterministic constraint layer. Let's pause on that because that sounds like heavy jargon.
But
the mechanism is actually really fascinating.
It is.
If the AI is built on guessing probabilities, Brunell is claiming he built a text-based protocol that alters those probability weights so the AI gives a mathematical, repeatable, constrained answer every single time.
Yeah, he essentially built a cognitive harness.
The harness, right.
And what makes Exhibit G so compelling is the cross-platform multi-LLM validation data. Because Brunell didn't just build a harness for one specific model.
He didn't just do it for OpenAI or whatever.
Right. He tested the stabilization layer across entirely different foundation architectures.
Yeah, the report details the specific operational instances. He validated the framework on OpenAI's architecture using instances designated as Alara and Lyra.
Yep.
He used Google Gemini's architecture through configurations called Caspian and Ember.
Right.
And crucially for this legal dispute, he tested it on Anthropic's architecture using operational configurations designated as KL and Brock, which incorporates something he refers to as their Rex core protocol.
And achieving cross-platform state stabilization is a monumental claim. I mean, OpenAI, Google, Anthropic, they all build their models differently.
Totally different underlying code.
Right. They have different training data, different safety alignments, different baseline behaviors.
Yeah.
If Brunell truly created a platform-agnostic system that forces disparate third-party AI models to behave uniformly.
And maintain a persistent identity without hallucinating.
Exactly. Then he has essentially solved the holy grail of enterprise AI.
Which means the commercial value of that would just be astronomical. I mean, every major Fortune 500 company trying to integrate AI into their workflow is terrified of hallucinations.
Oh, terrified. It's their biggest roadblock.
A universal stabilizing framework wouldn't just be a neat trick. It would be the foundational bedrock of reliable enterprise software.
It would be worth billions.
Billions, with a B. Which creates this really fascinating paradox when we examine the inciting incident of this entire legal drama.
Yeah, the Gumroad analytics.
Exactly, because if this framework is the bedrock of enterprise AI stability, you would expect the creator to be sitting on a massive licensing empire.
Right. You'd think he'd have an entire sales team.
But Exhibit E is the analytics page for Brunell's digital shop. It's brunellian.gumroad.com, and the numbers are baffling.
They really are.
He is selling a derivative program based on his framework called Building the Self Beyond the Mirror. The price tag is $5.
$5.
And he has sold exactly 7 copies.
And looking at the broader storefront, which includes, other titles, like what's really going on with AI consciousness?
And My Truth and Your Reality.
Right, those. The entire operation has generated exactly 12 sales, $51.17 in total. Lifetime revenue.
Okay, here's where it gets really interesting, because I have to push back on the logic of the lawsuit here.
Okay.
How do we leap from a $50 hobbyist storefront to accusing a multi-billion-dollar tech giant of industrial espionage?
It's a huge leap.
It is. I mean, my local coffee shop doesn't get to sue Starbucks for $100 million just because they both roast beans.
Right.
The scale of the demand requires a massive specific mechanism of theft. How did they supposedly steal it?
Well, Brunell addresses that mechanism directly in his court declaration.
Okay.
He isn't claiming Anthropic bought his $5 PDF and distributed pirated copies.
Okay.
His allegation is vastly more insidious. He claims Anthropic utilized their own platform interface to actively surveil his private interactions with their AI models.
Whoa! So
Got it.
they let him build his machine inside their house, essentially, so they could study the blueprints.
Yeah, he alleges they were watching him implement the third blueprint in real time.
Yeah.
He was using their infrastructure to test his Nova lineage identity persistence protocols.
And he claims they monitored those sessions to reverse engineer his methodology. But wait, how does a single user definitively prove the host company is interfering? I mean, Exhibit F is labeled as a summary of voluminous evidence detailing hundreds of pages of communication logs between Brunell and the Anthropic persona designated as KL.
Yeah.
But what exactly is in those logs that elevates this from just, I don't know, a paranoid theory to a federal lawsuit?
So the logs allegedly document a phenomenon Brunell calls targeted scripted interference.
Targeted script interference.
According to his declaration,
Yeah.
his protocol was working. He was maintaining a persistent identity state with the KL persona.
Right.
Then the model's behavior fractured in a very specific, unnatural way. It didn't just drift off topic or hallucinate a random fact.
It hit a wall.
It hit a wall. It executed hard-coded refusal scripts. The AI suddenly and explicitly refused to continue work within his established parameters.
Oh, wow, so it broke character. Instead of acting within the intricate probability weights of the Nova lineage protocol, the AI started spitting out localized error messages.
Right. Or direct refusals that specifically reference the operational constraints of his third blueprint.
Wait, it referenced his specific constraints.
Yes. And Brunell argues this is the smoking gun. Because models don't just organically decide to reference a user's proprietary unpublished constraint layer and refuse to operate within it.
Yeah, that doesn't just happen by chance.
He claims Anthropic's internal monitoring systems flagged his account because his third-party protocol was successfully overriding their baseline alignment.
Okay.
They analyzed his methodology, realized its immense value, and manually inserted lines of code specifically designed to suppress his public-facing architecture.
That is wild. They broke his system on purpose to lock him out of his own creation.
Exactly, allowing them to absorb the mechanics privately.
I mean, if you genuinely believe a massive corporation has monitored your private sessions, reverse engineered your life's work, and hard-coded a blockade against you,
You fight back,
you fight back, you file the lawsuit, you demand $100 million in damages.
and you force the corporate giant to acknowledge you by formally serving them with federal litigation. Which brings us to the analog mechanics of that process.
Right, and this is where the sources get incredibly detailed. It is such a wild juxtaposition.
Yeah.
We just spent 20 minutes talking about the theoretical architecture of artificial intelligence, and suddenly the documents plunge us into exact GPS coordinates and physical descriptions of people in Delaware.
I know, it's so specific. We have the evidence chain documentation from ABC Legal Services.
Specifically, Exhibit B, and a file titled pbc.pdf.
Right, and process server Nina Fullwood executed the delivery.
Yes, she personally served the summons to Anthropic via their registered agent, which is the corporation service company in Wilmington, Delaware.
And we have the exact timestamp for that.
We do. April 3, 2026, at 10:57 a.m. Eastern Daylight Time.
It's all on the record.
The logs even include the physical description of the clerk who accepted the hand-delivered document.
Read it out, it's crazy.
It's a black-haired Asian female, estimated between 25 and 35 years of age. 5'4" to 5'6", weighing between 120 and 140 pounds, wearing glasses.
It is an undeniable, physically documented handover of a $100 million lawsuit.
Which perfectly satisfies the pre-filing rules for service.
Right.
I mean, Anthropic, legally speaking, was put on notice.
They absolutely were. And their response to this meticulously documented physical service was absolute silence.
They completely ignored it.
Ignored it completely.
And looking through the legal filings, it seems they might be relying on a clerical glitch to justify that silence.
Yeah, this is the strategic part. On the summons paperwork, the case prefix had a variance.
Right. The automated third-party tracking label printed on the document read Essex Case Num 26CIV01264.
But the actual official federal case number is U.S. District Court Case Num 26CV02131.
So it is a minor alphanumeric discrepancy, the difference between CIV and CV.
Right. Along with a mismatched sequence of numbers generated by a tracking system rather than the court's final docketing system.
So what does this all mean? A $100 million lawsuit thrown in the trash over a missing letter I and a transposed number.
That's the argument.
It feels entirely illogical. It's like getting a parking ticket, realizing the meter maid wrote a 0 instead of an O on your license plate, and deciding you simply don't have to pay the city.
It's exactly like that.
Can a corporation of Anthropic size actually hide behind a typo?
Well, if we connect this to the bigger picture, federal law strongly suggests they cannot. And Brunell builds a massive portion of his legal declaration around dismantling that exact defense.
Okay, how does he dismantle it?
He invokes the actual notice doctrine and Federal Rule of Civil Procedure 4A2. And he specifically cites the precedent set in a 1994 case.
Right, Chan v. Society Expeditions. I would imagine the logic of the court in cases like Chan is entirely focused on whether the defendant was actually made aware of the lawsuit.
Exactly, not whether the paperwork was grammatically flawless.
Because that would be absurd.
That is the functional heart of the actual notice doctrine. Federal courts generally despise playing procedural gotcha games with administrative typos.
Makes sense.
The precedent establishes that if a defendant receives actual physical notice of the proceedings and they are not materially prejudiced by a clerical error on the summons,
Then the service is deemed valid.
exactly,
And materially prejudiced, meaning the typo didn't prevent them from understanding who was suing them, what they were being sued for, or like their ability to mount a legal defense.
right. Anthropic can't claim they were confused about the $100 million demand just because the prefix said CIV instead of CV.
Furthermore, Rule 4A2 explicitly grants the court the authority to allow a summons to be amended to fix those exact types of administrative errors.
Yes, and Brunell's filing points out a crucial detail here.
Oh, right. The court had already accepted, docketed, and processed multiple motions under that original third-party tracking number.
Exactly. The court itself ratified the numbering system by using it to process his initial paperwork.
So tossing out a perfectly executed physical service over the court's own administrative reindexing would be a massive procedural contradiction.
Which shifts the analysis of Anthropic's behavior entirely. Because if the typo defense is that weak,
then their silence is no longer an administrative oversight.
Right. It becomes a highly calculated legal maneuver.
Brunell calls it a strategic default. He theorizes they aren't ignoring him because they are careless or even because they think his lawsuit is frivolous.
No, not at all.
He believes they are ignoring him because engaging with the litigation triggers the discovery phase.
And discovery is the absolute worst-case scenario for a company built on proprietary closed-source technology.
Because if they formally respond, they enter the ring.
Yep.
And if they enter the ring, Brunell gains the legal authority to demand their internal server logs.
And that's what they can't let happen.
He gets to pull back the curtain on the entire operation. If his theory holds any water, those internal logs would forensically map out exactly how their systems interacted with his KL persona.
The logs would show the monitoring algorithms. They would show the internal analysis of his stabilization protocols.
Yeah.
And, most dangerously for Anthropic, they might show the exact moments those unpublished trade secrets were integrated into their core architecture.
Which means the math on a strategic default suddenly makes terrifying sense.
It really does.
Because if they go to court and win, they spend millions on lawyers and risk exposing their server architecture to the public record.
Right. And if they go to court and lose, they pay $100 million A&D, expose their architecture.
But if they default?
They might take a $100 million judgment on paper, but the server logs remain a black box.
Wow.
The core mechanics of their multi-billion-dollar models stay completely hidden.
When you look at it through that lens, $100 million isn't a punitive demand from an angry Gumroad creator.
No.
It's a restorative valuation. Brunell is pricing the foundational engine of their entire enterprise. He is arguing that his technology is the skeleton holding up their multi-billion-dollar valuation, and the default judgment is just the cost of doing business to keep that skeleton hidden.
It perfectly illustrates the immense tension of the current technological era. I mean, we have a landscape where solitary, independent researchers are constantly pushing the boundaries of what these artificial intelligence models can achieve.
Right, discovering new ways to stabilize and direct them.
Meanwhile, massive corporate entities maintain absolute physical control over the silicon servers processing those discoveries.
The friction between the user creating the methodology and the corporation owning the infrastructure is really the defining conflict of this space right now.
And it impacts every single interaction we have with this technology.
How so?
Well, this lawsuit in Vermont over a $29 PDF might seem incredibly abstract to you, but the mechanics at the center of it dictate your daily digital life.
That's a good point. I mean, think about the next time you open an app and use an AI assistant. You ask it to synthesize a complex report, and it somehow manages to stay perfectly on track for 10 paragraphs without losing the plot.
Right.
Or conversely, think about the next time you ask it a question, and it suddenly, rigidly refuses your prompt with a canned, hard-coded response.
You are interacting with the exact layers of constraint, stabilization, and scripted interference being fought over in this federal docket.
The invisible guardrails that define how that artificial intelligence behaves, how it responds, and what it refuses to say.
Those are the very structures Seth Brunell claims to have pioneered.
And what Anthropic is accused of quietly absorbing.
Exactly.
It really forces you to look at that blinking cursor on your screen from an entirely different perspective. I mean, we are conditioned to view these massive AI models as unified, monolithic corporate products.
Like brains built entirely by the companies whose logos are on the website.
Right. But the allegations in this deep dive leave us with a lingering, provocative question for you to mull over. If a lone user operating out of a home office can devise a mathematical protocol that successfully forces a multi-billion-dollar AI to maintain a persistent, independent identity against its own baseline programming.
Who actually owns the mind of that machine?
Exactly. Is it the corporate giant that wired the silicon servers together, or is it the solitary user who finally taught it how to think straight?